Dayne, let me ask you, Dayne. Do we need more than an affidavit? Do people have to come in and testify? Like, how do I know if this is true? Like I said at the top, no offense to anyone here, but anytime I see a defense lawyer after a conviction making a statement, I break out a big grain of salt, right? Because your job is what you need to do. But what are your thoughts tonight, Dayne? How do we figure out if all these allegations are true?
Well, I've actually been involved in an after-discovered evidence case early on in my career, and that initial step with the Court of Appeals, because remember, his case is pending before the Court of Appeals. They're filing a motion to suspend the appeal, basically hold it on, basically put it on pause, and then ask to send it back to the circuit court, to Judge Newman, to have an evidentiary hearing to hear evidence. And so that initial threshold with these affidavits is enough. In our case, it was enough. That's what we had to do, was file affidavits.
So to get a new trial, what you're saying is we need to get a hearing in front, they need to get a hearing, not me. They need to get a hearing in front of Judge Newman, bring in these jurors, let them testify, let them be cross-examined, and maybe bring Becky Hill in?
Not maybe, 110%.
110%.
She absolutely, she's a critical witness to this hearing.
All right, I ask you, Dayne, this to me, like, Becky Hill, and I say this is if again, right? It's if it's true. Like, but Becky Hill knows that the clerk can't talk to the jury about how to watch evidence, how to look at evidence, what to, can't ask about anything. Like, the jurors can't talk to anyone except themselves once they start deliberating. But before the deliberations, they can't talk to anyone about the case, not even their spouses, right?
Nobody, period. It invades what we call in legal terms, invading the province of the jury. It's a sanctity that once you go into the deliberations, and really during that whole process, the jury is cut off. It just flies in the face of the touchstone that we all look at in terms of the right to a fair trial and impartial jury. As you heard, it could be misconduct in office, jury tampering. These are all allegations, nothing proven, but if true, rots the fundamental principles of his right to a fair trial and impartial jury, regardless of whether you believe he's guilty or not guilty. This is a pivotal moment that ultimately, depending on the testimony presented at that evidentiary hearing, probably his best shot at receiving a new trial by far.
Wow, okay. So this is huge. I'm not exaggerating, folks. You're listening to the best of the best down there in the Low Country. So, Dayne, what if this turns out to be true? Like, if this is what the testimony is, could you? Because I rarely see like the trial judge say, "Oh yeah, we're going to do this again." Could you see, though, in this scenario, if everything falls into place for the defense, and they get this hearing in front of, well, it won't be in front of Newman, you're saying. Is that automatic that it won't be in front of Newman? That does he have to take himself out? Is that a motion? How does that work?
As soon as the defense calls him as a witness, then he is no longer able to preside over. He cannot be judge and witness in the case. So that becomes, from a procedural standpoint, a very significant issue. So given the fact that there was discussions that happened not on the record, that you would require witness testimony, sworn witness testimony, I believe he would be a witness. And at that point, you have the issue where they would have to ask that Judge Newman be recused from that evidentiary hearing, as he would be called as a witness to testify as to his own personal knowledge as to what happened. And see, in these motions for a new trial based on after-discovered evidence, there's a 5-factor test that you look at. And I think one of the biggest things that ultimately whichever judge is going to have to preside over that evidentiary hearing when they make that determination is, would the outcome probably change, or would this after-discovered evidence probably change the result of the new trial? That's probably the biggest thing, because clearly this is newly discovered evidence. It didn't exist. They couldn't have found it. It's absolutely material evidence. And it's not merely cumulative and impeaching. And I know I'm going deep into legal terms, but
No.
the biggest thing is that
It's the most important thing. It's the jury.
Right.
Like, it doesn't get more important than this. Wow, this is just explosive tonight.
Look, as Jared said, it could be structural from that point where they presume prejudice, and that at the end of the day, when you invade the province of the jury, the only way to remedy that and to have the sanctity of a true verdict, as they say, would be a new trial.
New trial. All right, great to have everyone with us tonight. Jared Newman, Lori Murray, Dayne Phillips, Christopher Adams. Thank you all so much working through this. I think we'll be talking about it again, like very soon. Meanwhile, coming up next hour.